You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 122, How to Defer Payment for COVID-19 related provisional patent applications. My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond Patent Law in Los Angeles, California. I can be contacted through my website at diamondpatentlaw.com. That's DIAMENT patentlaw.com, or call me at 424-281-0162. This episode is about another special program the USPTO has set up for COVID-19 related applications. In the last episode, I talked about how to get your application put in front of the line for examination if your application's COVID related. But it can be pretty hard to do because it has to be the subject of some kind of FDA regulation. And even if you have something that might be COVID related, like a new hand sanitizer or something, it might not qualify because it's not going to be through any kind of FDA approval. There is another program that you might be interested in, and it's called the Deferred Fee Provisional Patent Application Pilot Program. To be honest, this is probably going to save you $75 or $150 because it allows you to not pay the provisional patent application fee until you file your non-provisional. If you're not familiar with the differences between provisional and non-provisional applications, go back to my provisional patent applications episodes. But it's basically a low-cost application that allows you to get an earlier filing date for up to 12 months before you file your real or non-provisional patent application. And the filing fees are either $75 if you're a micro entity, which is generally a person making less than $206,000 currently, or $150 if you make more than that. There are other rules about how much you have to pay, but that's generally how it's going to work. If you're a large company, over 500 people, then it would be $300. But the odds are, that if it doesn't apply to you and you're a company of over 500 people, you're probably not worried about saving $300. What this pilot program does is that if you submit an application designed to combat COVID-19, you don't need to pay the filing fee when you file. You defer that payment until you file your regular or non-provisional patent application. The program started on September 17th, 2020, and it's scheduled for 12 months, but it's possible they could extend it, but it might end by September 17th, 2021. So what's the catch besides being COVID-19 related and the fee? One catch is that you have to agree that the technical matter disclosed in your provisional application has to be made available to the public via a searchable collaboration database by the PTO. Now, normally, provisional applications are not publicly available, so you can file a provisional application and no one will know about it. But if you do this program, they're going to make it publicly available. Also, like the other program I talked about in the last episode, the product or process must be subject to an applicable FDA approval for COVID-19 use, whether it's pending or will be sought prior to marketing. There is a form you have to fill out called PTO SB 452 to request being part of the pilot program. You have to include a technical disclosure, a cover sheet, and submit it in DocX format. I like to submit things in PDF, but the Patent Office is really trying to encourage DocX submissions. So now if you want to do this program, you have to do DocX. When you submit it and you're selecting the type of document description, when you upload the form, you select the description that says COVID-19 Collab Database Request for Provisional Application under the Pilot Programs category. Honestly, because of the requirements of being subject to an FDA approval, and you really, will be saving $75 or $150, it's not that big of a deal if you don't do it. At worst, you're out $75 or $150 because you didn't know about the program. And at best, you deferred payment of that $75 or $150. Not that you actually don't have to pay it, but you just deferred it. So I don't know how useful it is, but at least you know about it. And in the words of G.I. Joe, now you know, and knowing's half the battle. And if you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, or anything else related to your application, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com, or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.